Hello there, welcome to today's lecture on statutory interpretation, where we're going to examine the role that the judiciary has in interpreting statutes. So we have three learning objectives that you will achieve by the end of this lecture. We have a lower level learning objective, which is to understand the judicial role in interpreting statutes. So you will, by the end of this lecture, be able to explain how the judiciary perform their role in their function of interpreting statutes. We have then a little higher level learning objective where you'll be able to make your own assessment on the approaches to statutory interpretation. So you'll be able to examine the advantages and the disadvantages of statutory interpretation and make an assessment for yourself in relation to how the judiciary perform that function. And then our highest level learning objective is for you to make an evaluation upon the impact of the Human Rights Act on statutory interpretation. So the Human Rights Act has had some profound changes since it came into force in the year 2000 upon the role of statutory interpretation, and you'll be able to make an evaluation in relation to the way that the Human Rights Act has impacted that role. So how are we going to do this then? This is our agenda. So we're going to look at first of all the ambiguity of words and sentences and really see why it is that the judiciary need to perform this function. And then we'll look at rules or approaches to statutory interpretation. You'll note I've put the word rules in inverted commas because quite simply there is an academic debate as to whether these are actually rules or not. I think when we talk about a rule, we're talking about a rule whereby someone is under a duty or an obligation to perform that particular command that's within the rule. So even though they're quite often referred to as rules of statutory interpretation, maybe it would be better to refer to them as approaches to statutory interpretation. And then we'll have a look at a move towards a purposive approach in interpreting statutes. So we'll have a look at what purposive approach means and how that has come from the way that the judiciary interpret codes and interpret the law, in particular on the continental system. And what we see is more of a fusing together of the different approaches between the English and Wales legal system and the system that we have on the continent. So we see more of a move towards a purposive approach, and we'll see how that has developed in recent years. And then we'll look at the advantages and the disadvantages of the approaches, and maybe you could think of some advantages or disadvantages of your own as we're going through that too. And then finally we'll have a look at the impact of the Human Rights Act, which has had a profound change on the way in which the judiciary can interpret statutes. So much so that there has been some academic discussion as to whether this has given more power to the judiciary as a state organ. So we will examine the role that the judiciary now has in statutory interpretation by means of the impact of the Human Rights Act. So what is then statutory interpretation, I think, is a good starting point. Why do judges need to adopt particular approaches in relation to statutory interpretation? Well, quite simply, Parliament creates the law, and the judge's role is merely to apply that law. So, bearing in mind the doctrine of parliamentary supremacy, it is the Parliament's role to create the law constitutionally, and the judge's role is merely to apply that. However, to do so, they need to interpret the statute. The statute may not give clear guidance in its words. There may be some ambiguity in its wording. It may not always be clear. The statute may be an old statute, so by way of example, when you go onto criminal law, you will see that when we refer to assault and battery and offences against the person in that sense, moving on to grievous bodily harm, actual bodily harm and whatnot, the statute that you're going to be examining there is an 1861 statute. The Offences Against the Person Act. And as language changes over time, we can also see that there may be some dated language in statutes, particularly in older statutes. So the judiciary need to have a way to interpret these statutes, to apply them to the modern contexts. So it's not always clear to the case before them, and we'll do a little exercise in a little while to demonstrate that words used in statutes may not always be clear. And Benyon in 2005 he identified a number of factors that may cause particular uncertainty in statutes. And he states a word is left out because the draftsman thought it was automatically employed. So there may be a case where the draftman just assumes that that word should automatically be employed. For example, a draftsman writing a statute banning men with facial hair from parks might write men with beards or moustaches are prohibited from parks. If you read that in a literal sense, does that mean that a man who has a beard and a moustache would be allowed in? So you notice that how that word "or" has a particular meaning. Men with beards or moustaches are prohibited in parks. This fictitious draftsman would quite simply assume that it would apply to people with a beard and a moustache, but he doesn't actually state that. And then he goes on to say if words and or were used, it would be clear, but the draftsman may have thought that this was automatically implied. And a particular problem that we have is that when a draftsman assumes that words are automatically implied, that because of the age of some of the statutes, that what we have today when the judiciary has to interpret them is that they have to get into the mind of that person maybe 50 years ago, maybe 100 years ago, 150 years ago, and beyond it, as in the case of the Offences Against the Person Act. And quite simply, the original draftsman is no longer here and cannot provide any further clarification on the meaning of the words. And so the judiciary has to come up with ways of interpreting the statute, and we're going to look at the different approaches that the judiciary have. What I would like you to think about is, you imagine that you're a Court of Appeal judge and you're confronted with a law or a rule that bans vehicles in a park. On the face of it, it might seem quite a simple rule, that we want to ban cars, we want to ban motorcycles, quite simply for the enjoyment of people in the park, so that people are not put in any danger in any sort of way, so we can go about our recreation. We could have a picnic in the park without worry of vehicles being in the park. So a draftsman may, this fictitious draftsman may draft a statute that says no vehicles in the park. However, how do you define the word vehicle? Do you define it on the basis of something that has wheels? Well, if you do, you're banning wheelchairs, you're banning pushchairs. Do you define it, okay, on the basis of let's have a motor attached to it? Well, in that case, you're banning motorised wheelchairs. Do you define it on the basis of having an engine? Well, if that's the case, then people on bicycles, people on electric scooters, for instance, that we see, the new sort of electric scooters or electric bikes, or even, you can get electric cars. these days that drive as fast as any other car. So if we're going to do it simply on the basis of an engine, a petrol engine or a diesel engine, then we are allowing in vehicles that may well have been in the mind of the draftsman as being banned. So how do you get to define vehicles in a park? So imagine, reflect on it for a moment, pause the video, and imagine that you're this Court of Appeal judge. You've got two appeals in front of you and you're considering them together in one case. One concerns an individual in a motorised wheelchair, another concerns someone on a bicycle. Both have been fined for driving a vehicle in a park. You need to come up with a sensible definition of the word vehicle, ensuring that the purpose of the sign is adhered to. The park users, including mothers, pushchairs and those with disabilities, can still use the park. So you need to come up with a sensible definition, and quite simply what you could be looking at is the purpose of the statute rather than the words itself. And this is what we're going to see that the judiciary, or one of the approaches of the judiciary, do use when they look at the purpose. So maybe we need to look at the mischief that occurred before the sign appeared. Maybe we have to look at the problem and realise that people just quite simply could not enjoy their recreation because there were vehicles in the park. So on that basis, perhaps we can say that the bicycle qualifies as a vehicle, although it is a grey area. However, the motorised wheelchair, I think nobody in their right mind would be wanting to ban a motorised wheelchair from the park under this definition. So rather than the words then, what we would need to do perhaps is to look at the purpose behind the law, and rather than examine the words within itself. So this little exercise gives us some idea as to how a judge, you sitting as a judge, may interpret that particular rule or statute. So some of the rules that the judiciary has then, first of all, there are presumptions. So when it's not expressly stated otherwise in a statute, the judges presume these points. So the legislature does not intend to remove any matters from the jurisdiction of the courts. So the courts are under a jurisdiction to examine these matters. Another presumption is the laws which create crimes should be interpreted in favour of the citizen where there is ambiguity. And the reasoning behind that is because obviously you're talking about somebody's liberty. So if there is an ambiguity, it has to be interpreted in favour of the citizen. Next we have in favour of an assumption that a mental element is required for criminal offence. So unless it states otherwise in a criminal statute, we're going to consider that a mental element exists, being the mens rea. Then we need to consider a presumption of that legislation does not operate retrospectively, so it only operates going forward, unless of course the legislation expresses otherwise. And then against a breach of international law, so there is a presumption that the legislation will comply with international law. So these are some of the presumptions and the starting points that the judiciary has. What I would like to look at now are these rules to statutory interpretation that the judiciary considers. And as I mentioned at the beginning, to call them rules is probably a little bit misleading, because a rule would perhaps dictate that the judiciary has to apply a particular approach, and what we'll see is the judiciary quite simply adopt these particular approaches. So it may be better to call them approaches, however you'll be reading in your textbooks and beyond that these are referred to as rules, so we will stick with that particular way of entitling these approaches. So first we need to consider the literal rule, and the literal rule quite simply follows the ordinary and natural meaning of words, even if that particular rule results or even if following the rule, I should say, results in an absurdity. So Lord Esher in R against City of London Court Judge in 1892 states, if the words of an act are clear, you must follow them, even though they lead to a manifest absurdity. The court has nothing to do with the question of whether the legislature has committed an absurdity. However, if the words of an act admit two interpretations and one interpretation leads to an absurdity and the other does not, the court will conclude the legislature did not intend the absurdity and adopt the other interpretation. So there's an element of flexibility if there's an absurdity there, or if that absurdity is the result of an ambiguity. So there is an element of flexibility. However, the judiciary follow the literal meaning. And what this does, it respects parliamentary supremacy, the doctrine of parliamentary sovereignty, it respects the constitutional role of the judiciary in relation to that. And some examples that we have, there are numerous examples, but I've chosen two here. So we've got Whiteley against Chappell and R against McGuinness. So in Whiteley against Chappell, the particular statute concerned there made it an offence to impersonate any person entitled to vote. And the defendant in this case used the vote of a dead person. But note that the statute stated it was an offence to impersonate any person entitled to vote. And what was ruled in that case, taking this literal approach, that a person who was entitled to vote had to be a living person. A dead person, quite simply, is not a person entitled to vote. So in that case, the fact that the defendant used the vote of a dead person meant that he was not impersonating any person entitled to vote. So arguably it leads to an absurd result, because the purpose of the statute was to make sure that people did not impersonate others, and it was an attempt to restrict voter fraud. So there was an absurdity resulted there. However, acknowledging parliamentary supremacy, the judgment held in favour of the defendant. Our next case concerns a defendant that was essentially charged with the possession of a controlled drug with intent to supply it to another, and this was under Section 5.3 of the Misuse of Drugs Act of 1971. And in that case he was found with a package of cannabis. It was worth £500 within his car, and he was essentially claiming that the cannabis belonged to a friend, and the friend was picking it up later. So to charge him with intent to supply, which is sort of drug dealing, he argued that he wasn't intending to supply it, he was simply holding it for a friend. And what was held on that particular case was that when it got to the House of Lords, that reinstated the conviction, the Court of Appeal quashed the conviction, that what they held was that the word supply should have its ordinary, natural meaning. So even though he was arguing that he was holding it for a friend, he was still going to supply it because he was going to simply supply it back to his friend. So whilst the statute was attempting to capture drug dealing, intending to supply others, obviously by means of dealing, he was still actually attempting, despite his defence, he was still actually attempting to supply, or going to supply, because he was going to supply it back to his friend. So what we can see there is the way that the literal rule has been used to capture this particular issue, despite the fact that the defendant was claiming that they were simply holding it for a friend. So in relation to the literal rule then, some of the advantages, as I've mentioned, it does respect parliamentary sovereignty. So it limits judicial activism, so the judiciary cannot interpret a statute outside of its literal meaning, respecting the constitutional role of the judiciary. However, some of the disadvantages are that words are imperfect as means of a communication, so it can quite often result in an absurdity or sometimes an unjust conclusion. And the Law Commission noted that it assumes an unattainable perfection in draftsmen, so it assumes that the draftsmen were perfect in the way that they wrote that particular statute. So what we move on to next is the golden rule, and this is essentially an extension of the literal rule, but it avoids absurdities, whereby a judge can quite simply substitute a reasonable meaning in light of the statute as a whole. So it perhaps takes more of a contextual analysis of the statute, where it would otherwise lead to an absurdity. And Lord Wensleydale, in Gray against Pearson of 1857, he said the grammatical and ordinary sense of the words is to be adhered to, unless that would lead to some absurdity or some repugnance or inconsistency with the rest of the instrument, in which the grammatical and ordinary sense of the words may be modified so as to avoid that absurdity or inconsistency, but no further. And a couple of examples that we have here are Adler against George and re Sigsworth. So in Adler against George, what occurred there was that under the Official Secrets Act of 1920, it was quite simply an offence to obstruct a member of the armed forces in the vicinity of a prohibited place. And in this particular instance, the defendant was part of a protest and had got into an armed base, and were quite simply claiming that they were not obstructing members of the armed forces because they were no longer in the vicinity of the prohibited place, but they were actually inside the prohibited place. When you think about the word vicinity, if you're in the vicinity of, say, your college or your university, taking a literal meaning to that, it does mean that you're on the outskirts of it, you're somewhere nearby. It may not necessarily mean that you're inside. And this was the defence that was attempted to be used. However, the judiciary, taking the golden rule approach, that they realised that the literal rule would create an absurdity in this case, because without doubt the draftsman that wrote the statute up would have intended for it to also apply inside the prohibited place. So they essentially substituted the meaning of that in their ruling and allowed for being inside a place to also mean within the vicinity of the place, and preventing an injustice in that particular case. And then we have the golden rule being applied in a more wider sense. So Adler against George was a narrow sense, but in a wider sense we have re Sigsworth. And in that case, this was a son who had murdered his mother. She'd not made a will, and under the intestacy laws, he was the sole beneficiary, and he stood to inherit the entire estate. Applying the golden rule, it was held that an application of a literal rule in this case, whereby the son would inherit the estate, because there was an absence of anything to the effect that if you'd murdered the person, that it just did not say you could not inherit. It just wasn't there. However, the judiciary recognised that adopting a literal rule, that it would result in a repugnant result, and so they held that he was entitled to nothing as a result of his crime. So they established the principle that you cannot benefit from your crime in that particular context, and adopted the golden rule in their approach there. So some advantages then, it maybe it's a little bit better than the literal rule in that it does avoid absurdity, it prevents injustice, and it puts into practice really what Parliament had intended rather than what Parliament may have actually written. Some of the disadvantages, the Law Commission noted that in 1969 that the rule provided no clear meaning of what actually an absurd result meant. So there's an element of discretion in the judiciary in determining what an absurd result is. And each individual judgment is based on the facts, so it's considered on a case by case basis, and that in itself can create its own problems. So next we move on to the mischief rule, and the mischief rule was identified in Hayden's case, which posed 4 questions, and that's what the law was before the statute was passed, what problem or mischief the statute was trying to remedy, what remedy Parliament was trying to provide, what was the reason for Parliament adopting that remedy. And then the judge would then interpret that statute in such a way as to put a stop to the problem that Parliament was addressing. Examples we've got here are Smith against Hughes and the Royal College of Nursing against the DHSS. So in Smith against Hughes, the defendants in this case were prostitutes who had been charged under the Street Offences Act of 1959, which made it an offence to solicit in a public place. However, the prostitutes concerned were soliciting from their private homes. They were in windows or they were on balconies. They could be seen by the public, but they argued they were not in a public place because they were in the privacy of their own home. The court applied the mischief rule, holding that activities of the defendants were essentially within the mischief of the act. That even under a literal interpretation, they were in a private place as opposed to a public place. The use of the act was to prevent, or the mischief was to prevent street prostitution or to address street prostitution. And so, looking at the mischief and looking at what the act designed to do, they applied the mischief rule and quite simply said that the defendants were guilty under that act. Another good example is the Royal College of Nursing, and in that particular case, the Royal College of Nursing wanted to identify whether they were classed as registered medical practitioners in the context of performing abortions. So the Abortion Act of 1967 provided that it would be an absolute defence for someone who was carrying out abortions to be a medical registered practitioner. And what the judgment looked at here was how the act was designed to prevent what was known as the time as sort of backstreet abortions, where women were dying and becoming seriously ill as a result of a poorly performed abortion. And the act put into place the idea of a registered medical practitioner being present. The problem with that is if you adopt a literal interpretation of the medical registered practitioner, that could encompass dentists, veterinary surgeons. There's a whole host of professions that could be classed as a medical registered practitioner. And so what the court held there was, let's look at the mischief, let's look at what's designed to prevent, and most definitely nurses would be classified within that definition, adopting this mischief rule approach. Some of the advantages: it avoids absurdity, injustice, it promotes some flexibility too. As society changes, maybe there's a need to adopt different approaches to interpreting the same statute, so there's an element of flexibility there. In Hayden's case, some of the disadvantages: Hayden's case is particularly dated. Maybe such a rule is less appropriate now, and it does create a lot of judicial discretion. The judiciary is mindful that they lack a democratic legitimacy in the way that Parliament does, and so they need to be careful of creating this judicial discretion and creating a judicial sort of activism. And essentially, does it move on to the idea that the judiciary create law rather than simply apply the law? So what I would like to move on to now is the relationship between these rules. There is a question: is there a hierarchical order? And the three rules are quite contradictory, and even though the golden rule may well consider the literal rule first, what about the mischief rule? How does that play its part? So that's a particular question. In the context of the other rules, that is. What is to be considered as an absurdity in any particular place, other than the view of the judge deciding the case? So this idea of a result being absurd is really down to the judge to decide, and maybe it's handing more power to the judiciary to essentially create law rather than apply law. So because of some of these issues, there was a move to what was called the purposive approach, albeit with concerns that it does give the judiciary additional power. It looks for the purpose of the statute, which is what we're going to look at now, and this is a way of interpreting statutes that is perhaps being borrowed from continental systems, from the positive approaches of the continental system, into the way that they interpret the purpose of the codes that are being applied there, or that are being set out. And Denning in particular took a lead in this approach, which made it influential on the later judiciary. And he said there, we do not sit here to pull the language of Parliament and ministers to pieces and make a nonsense of it. We sit here to find the intention of Parliament and of ministers and carry it out, and we do this better by filling in the gaps, making sense of the enactment, than by opening it up to a destructive analysis. So for Denning, these rules were not really looking at the purpose, or the previous rules were not really looking at the purpose, but they were quite simply destroying the purpose of Parliament. And wouldn't it be much better to look at the purpose behind the statute rather than the literal words that you have in front of them? And there are avenues that we can look at in looking at the purpose, which Denning goes on to explain in particular in Pepper Against Hart, which we're going to look at next. And this is being influenced by the European approach, giving effect to the purpose of legislation rather than examining the words itself. So in Pepper Against Hart, what happened in this particular case was Denning wanted to examine the Hansard Library, which is a library of the debates in Parliament. So when a statute is being created, there are a series of debates beforehand by politicians, and in the lead up to the creation of that statute. So what Denning wanted to do was to look at the purpose behind the statute, and what better way to do that is than to examine the Hansard Library. But there was a lot of resistance towards that in the judiciary, because politicians say a lot of things in the build up to statutes, and perhaps it would be wrong to examine the politicians' debates and examine perhaps it would place a restriction on politicians wanting to debate a particular issue if they felt that debate led to the actual creation of law. Wouldn't it be better from a political point of view to be looking at the words rather than the debate? However, for the judiciary, they felt that looking at the purpose of the statute, or Denning felt that it would be better to look at the debates that had occurred up until that point. And when this reached the House of Lords, Lord Denning said, the days have long passed when the courts adopted a strict constructionist view of interpretation, which required them to adopt the literal meaning of the language. The courts now adopt a purposive approach which seeks to give effect to the true purpose of the legislation, and are prepared to look at much extraneous material that bears upon the background against which the legislation was enacted. So the traditional approaches that we have, the traditional rules, Lord Griffiths is here in saying in 1993, as these days have long passed when we're looking at this strict constructionist view. We need to infuse our interpretations with looking at the purpose. And so perhaps the three rules are now outdated in respect of the way that the judges interpret statute. And none more so has this been impacted upon than in relation to the impact of the Human Rights Act of 1998. And what we have when the Human Rights Act was enacted, these two sections of the Human Rights Act, which say, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. So now you have a case where a statute needs to be interpreted. It says, so far as it's possible to do so, to give accordance to a Convention right. And then section 4.2, it says if the court is satisfied that the provision is incompatible with a Convention right, it may make a declaration of that incompatibility. So the judges can now make a declaration that a law is incompatible with the European Convention of Human Rights. It doesn't destroy the validity of that act. Quite simply, they pass it back to Parliament, respecting the doctrine of parliamentary supremacy. Pass it back to Parliament to decide a way forward. So what we have are these two sections of the Act, and what we see in the way that recent history has developed statutory interpretation is that the judiciary deal with section 3.1 first, and then refer to section 4.2 more as a last resort if they can't make the legislation as far as possible to do so to give effect to Convention rights. However, just because the Act is written chronologically in this way, there is no hierarchy from the original drafters. It was just quite simply put down that way. But we will see now, as we look at a couple of cases, that the judiciary deal with Section 3.1 first before going to Section 4.2, and perhaps give primacy to Section 3.1 before referring to Section 4.2. And so Lord Steen was really the first one to look at Section 3.1 in R against A 2001 at the House of Lords. And in this case, it concerned the use of evidence of a complainant in a rape case, and the defence wanted to look at the complainant's previous sexual history in the context of the history between them. However, the statute quite clearly said that a complainant's sexual history should not be part of the evidence to be relied upon by the defence. And what Lord Steen said in this particular case, because it was appealed on the basis of the defendant felt he did not have a right to a fair trial, he says the interpretive obligation under Section 3 of the Act is a strong one. It applies even if there is no ambiguity in the language. So no longer are we looking at ambiguity in the way that the three traditional approaches looked at, in the sense of the language being capable of two different meanings. So in accordance with the will of Parliament, he says in relation to Section 3, it will sometimes be necessary to adopt an interpretation which linguistically may appear strained. So despite the statute stating that the complainant's sexual history should not be considered as a defence, when interpreted in the context of the right to a fair trial of the defendant, Lord Steen is saying that we may have to adopt a position where there is a linguistic strain, so there's no ambiguity in the particular statute concerned. There is an adoption now of what seems to be linguistically appear strange, and because of that, he said using Section 3.2 it would subordinate the niceties of language to interpret the provision to take into account of modern considerations of relevance judged by logical and common sense criteria of time and circumstances. And so in that particular case it was held that it should have been considered as part of the defendant's defence, and on this basis Lord Steen was at pains to avoid the declaration of incompatibility in the statute concerned. So there was this linguistic strain now, and arguably this creates some judicial activism, some judicial some real hoops that the judiciary have jumped through to interpret statutes. Similarly, in Garden and Mendoza, the House of Lords there held it was possible to read down the 1977 Rent Act, which had allowed for a surviving spouse to take on a tenancy under the Human Rights Act, so that it was compliant with the rights in the Convention. The court in that case decided that the failing could be remedied by reading the words "as his or her wife or husband" in the Act, as meaning as if they were his or wife or husband, to allow a homosexual partner to benefit. So in that case they read down, and in the previous case there was words that was essentially read into the statute. So what we have here in these cases are the judiciary really adopting an approach that not only looks at the purpose of the statute now, but looks at the purpose of the statute in the context of the Human Rights Act. And so they have to adopt an approach that arguably allows them more creativity in their interpretation of statutes. If they can't do that, however, they refer to Section 4.2, and in that particular case, if they do issue a declaration of incompatibility, it's important for you to note that it doesn't affect the validity of the Act until Parliament decides to change the Act. They simply hand it over to Parliament to change. So in A against Secretary of State for the Home Department in 2004, under there, known as the Belmarsh case, suspected international terrorists who could not be deported for various reasons were held essentially without trial because of the suspicions that the intelligence services had that they were involved in terrorism. So Section 23 of that particular Act was declared to be incompatible with Articles 5 and 14 of the European Convention of Human Rights, it was disproportionate, and it also discriminated on the ground of nationality or immigration status, because the statute held that this applied to foreign nationals, and it was held in that case that it was incompatible because it should apply to everyone rather than discriminate on the basis of foreign nationals. So it was essentially handed back to Parliament. The validity of the Act was not questioned. It was still in force despite the judiciary declaring a declaration of incompatibility, and so Parliament essentially repealed the Act and replaced it with the Prevention of Terrorism Act 2005 to make sure that it was convention compliant. We have, which is an interesting case, the prisoner voting saga was a series of cases whereby there's a blanket ban on prisoners being allowed to vote, and there was a series of cases that was brought before the court that should allow people to participate in free and fair elections, and this blanket ban was seen as being contravening the European Convention of Human Rights. And despite the back and forth of that and the judiciary, and even going as far as the European Court of Human Rights in Hurst against the United Kingdom, that declared this ban as being incompatible with convention rights, Parliament had decided in a vote overwhelmingly to carry on with this ban, despite these judgments against it. And the culmination reached the Chester case, where the Supreme Court just quite simply declined to make a declaration of incompatibility. If you read between the lines on the judgment there, you can see that they do recognise that there would be, quite simply, be a declaration of incompatibility. However, the judiciary are not going to keep carrying on declaring declarations of incompatibility because they recognise Parliament has made a clear decision on that matter. So they don't want to set themselves off as being set up against Parliament in that context. So that was an interesting case where they declined to make that declaration of incompatibility, despite the fact that they could quite easily have done so. So I would advise you to read that case and have a look at the reasoning behind that. So some concerns then about interpretation, and some concerns are the constitutional role of the judiciary. What we see in more recent years, particularly adopting this purposive approach in the Human Rights Act, is that the judiciary is being more geared towards creating law as opposed to applying law, from an academic debate that is. So that's a particular concern we need to look at, and how does that impact on the constitutional role of the judiciary, knowing that the judiciary are not democratically elected. Judges may abuse their role as interpreters. We don't really see that. I think there's an acknowledgement that the judiciary are using their role in the manner in which they should. However, there is a concern that there could be an abuse of their role. And then some argue that statutory interpretation involves creating law, and essentially judges being the source of law in this sense, which goes against principles of parliamentary supremacy. So that's an academic debate you may want to look into. And then it allows for this concept of judicial creativity. So what I would like you to think about in the context of statutory interpretation is that even though we consider the three traditional roles, those roles are purely traditional roles, and we're looking more towards other roles now. So most certainly, if you are asked a question of it, those three roles do serve as the context for statutory interpretation, but you really need to be considering the purposive approach and the context of the Human Rights Act in your answers to this question, rather than simply giving a rote of three traditional interpretations, because as was said there, those three traditional interpretations may not apply any longer, particularly in the context of the Human Rights Act. So by way of summary, we've examined the rules or approaches to statutory interpretation. We invite you to make an assessment on the move towards a purposive approach in interpreting statutes. Evaluated the advantages and the disadvantages of certain approaches, particularly in the context of parliamentary supremacy and judicial creativity. And then we've considered the impact of the Human Rights Act. So our final thought: words are not as satisfactory as we should like them to be, but like our neighbours, we have got to live with them and must make the best and not the worst of them. Samuel Butler.